It is my privilege to welcome you to the 11th BRICS Legal Forum 2026, hosted by the Bar Association of India. We are honored by the presence of distinguished members of the judiciary, senior members of the legal profession, policymakers, academics, eminent representative of the legal fraternity from across the BRICS Plus jurisdiction. May I request everyone to kindly remain seated as we start the formal proceeding of the BRICS Legal Forum, the inaugural plenary of the Legal Forum. The theme of this year's Legal Forum is Rule of Law, Frameworks and Institutional Capacity Building for Economic Resilience, Innovation and Sustainability. The inaugural plenary is titled Rule of Law in a Multipolar World, Building Legal Capacity for Economic Resilience. To begin the proceedings, may I now call upon Mr. S.S. Naganand, Vice President, Bar Association of India, to kindly deliver the welcome address. Mr. Naganand.
Good morning to everybody. Honorable Chief Justice of India, Honorable Judges, distinguished delegates, dignitaries, excellencies, members of the legal profession, ladies and gentlemen, and dear students. It's a great privilege for me, on behalf of the Bar Association of India, to welcome all of you to this very important gathering. Let me begin by expressing our sincere gratitude to the Honorable Chief Justice of India for being with us today. Sir, your presence makes this occasion particularly special for all of us and all the delegates who have assembled here from all the BRICS countries. I would also like to extend a very warm welcome to all our friends and colleagues who have travelled from different parts of India and particularly from various BRICS plus countries. We are very happy to have you with us in New Delhi. When BRICS was formed, the principal focus was on strengthening economic and financial cooperation between member countries. Over the years, BRICS has grown into a much broader platform for engagement and cooperation. As the economic relationships grow, legal relationships inevitably grow with them. Businesses from our countries are increasingly entering into commercial arrangements with each other. Investments are crossing borders, projects are becoming more complex, and naturally disputes will sometimes arise. The important question then is, how do we resolve those disputes? This is where I believe the legal fraternity has an important role to play. We need dispute resolution mechanisms which are efficient, accessible, and cost-effective. Parties should not have to spend years and enormous resources merely to obtain a resolution of a commercial dispute. That is why arbitration and mediation assume such importance. The establishment and development of BRICS Legal Forum provides with an excellent opportunity to look at these issues collectively, to understand each other's legal systems, learn from each other's experience, and explore how we can make dispute resolution between our countries simpler and more effective. The Bar Association of India is very conscious of this need. It is with this objective that the Bar Association of India has taken the initiative to establish a BRICS Arbitration Center in New Delhi. We see this not simply as creating another arbitral institution. We see it as an opportunity to build a forum which can be trusted by parties from across BRICS countries. A forum which is professional, neutral, efficient, and importantly, cost-effective. India has a long and rich tradition, an independent judiciary, a large and experienced legal profession. We hope that the BRICS Arbitration Center will become a place where not only disputes are resolved, but where legal professionals from across countries meet, exchange ideas, and build lasting professional relationships. Ultimately, institutions are not built only by rules and procedure. They are built by people, by professional integrity, and above all, by trust. And that perhaps is one of the most important purposes of our meeting today. I hope that our discussions will go beyond arbitration. I will hope it will also discuss mediation, cooperation between legal institutions, and the larger question of how legal communities of the BRICS countries can work more closely together. We may come from different jurisdictions and have different legal traditions, but we share many common objectives. They are the rule of law, fairness, access to justice, and the need for disputes to be resolved efficiently and effectively. I am confident that this gathering will be the beginning of many more such conversations and collaborations. On behalf of the Bar Association of India, I once again extend a very warm welcome to the Honorable Chief Justice of India, all the distinguished dignitaries, and each one of our delegates from India and abroad. We are honored by your presence. We look forward to your participation and guidance during the deliberations. Welcome to India. Welcome to New Delhi. Welcome to BRICS Legal Forum. Jai Hind.
Thank you, Mr. Naganand, for setting the context for the BRICS Legal Forum and highlighting some of the larger questions that we are going to deliberate on for the next 2 days. Now, we have the privilege of having the Honorable, the Chief Justice of India, Justice Surya Kant, amongst us. May I request Lordship to kindly deliver his address.
Mr. Prashant Kumar, President Bar Association of India, Mr. Amarjit Singh Chandiok, President-elect Bar Association of India, Shri Amarjit Singh Bedi, Honorary Secretary, Mr. Bruno Barata, President, National Commission for Foreign Affairs and Secretary, Executive Committee, BRICS Legal Forum, Mr. Oleg Jetsev, Judge of Economic Courts of the Commonwealth of Independent State, Mr. Wang Okchiang, Executive Vice President of the China Law Society, President of Law Society of South Africa, President Ethiopian Federal Advocates Association, Head of International Cooperation Emirates Association Lawyers, Member Egyptian Bar Association, and Commissioner for Human Rights in the Russian Federation, very distinguished foreign delegates, Vice President Bar Association of India, Sri Naganand, other office bearers, Secretary and other office bearers of the Bar Association of India, members of the Bar Association, senior advocates, distinguished members of the legal fraternity, delegates, friends from media, ladies and gentlemen. A very good morning to one and all. It is an honor to address this inaugural session of the 11th BRICS Plus Legal Forum on a theme that is posing the right question to the legal fraternity at precisely the right time. Rule of law, frameworks and institutional capacity building for economic resilience, innovation and sustainability. A few months ago, at a similar conference, I found myself between sessions in conversation with a learned judge attending from abroad. He remarked that over the last few decades, the Indian justice delivery system has somehow taught itself to speak the language of the rule of law and the language of economy in the same sentence, while his own bench, in his own words, was still teaching itself to speak one language at a time. I find myself ruminating over that exchange quite often, because at the end of the day, it is not a compliment to India alone. I believe it speaks volumes to what forms such as this were made possible. The chance for the jurisdictions, the fluency to become a second language for all of us over time. The enormous growth that our nations are expected to sustain cannot solely arrive by the luck of geography or the accident of resources. It is built deliberately out of institutions strong enough to be trusted. Perhaps numbers and statistics can make the point better than words alone. The BRICS and associates nations today are home to more than 40% of humanity and account for something close to 40% of the world's output measured by purchasing power, larger by that metric than the G7. Within that grouping, India continues to be described year on year by the International Monetary Fund as the fastest growing major economy on the planet at a pace nearly double the global average. The scale at which our country is progressing, and this holds true for each of the BRICS plus nations, owes itself to the nature of our institutions, the judiciary being chief among them. Institutions are not scaffolding we erect around growth once it has already begun. They are its architecture. Take the architecture away, and in truth, what looks like a rising economy is a stack of good fortune waiting for its first storm. This architecture, upheld primarily by institutions such as the justice delivery system, offers three things: trust, predictability, and stability, each a direct byproduct of studied allegiance to the rule of law. It is this and nothing more mysterious than this that allows any economy, including India's own, to flourish at the pace we have already put a number to. In fact, I have attempted to coin a term that would perfectly describe the marriage between the rule of law and how it permeates favorable economic conditions: Nyayanomics, or more simply the economics of justice. It is a fact that consistent adjudication and trust in the process reduce the cost of each transaction built upon it, thereby leveling the playing field for market forces and in turn making way for growth. No BRICS plus economy, including India, has achieved growth solely through its resources. Our development has been proportional to the enforceability of our commitments. Allow me to transition from the theoretical to the practical, as a promise is most readily admired in abstraction but is not challenging to uphold within a real courtroom where a commercial party awaits to ascertain the validity of its agreement. Most of those who are well conversant with the Indian judicial system are aware that the Supreme Court in 2012 in Bharat Aluminium drew a line that international commerce had been waiting the better part of a decade for, namely that the Indian courts would no longer reach into an arbitration seated outside India simply because one of the parties happened to be Indian. The seat, not the litigant's address, would decide whose courts had a say. Less than a decade later, in Wind Solution, the Supreme Court went further, holding that even two Indian companies were free to choose a foreign seat for their own arbitration, if that was the bargain they had struck. Party autonomy, the court held, did not stop being party autonomy simply because both parties happened to share a passport. More recently, the Supreme Court has spent its attention on the question that decide whether an arbitration clause survives contact with the real world. In Cox and Kings, the group of companies doctrine has been applied in the case of a company that never signed an arbitration agreement and can still be bound by one because of how closely its conduct was woven into the bargain. In a 7-judge ruling the same year, the Supreme Court sustained the arbitration clause notwithstanding the non-payment of stamp duty on the deed of agreement. In both, the court reached for the same instinct, namely that form should not be allowed to defeat intention, and a technicality should never be permitted to unmake a promise that parties actually meant to keep. The same instinct runs through our insolvency jurisprudence. When the Supreme Court upheld the constitutionality of the Insolvency and Bankruptcy Code and later affirmed that the commercial wisdom of a creditors' committee deserves primacy over years of open-ended litigation, it was making the same point in a different register, that is, capital recycled quickly is capital that returns, and capital trapped in litigation for a decade rarely does. None of this happened by accident, and none of it happened without cost to old habits of judicial caution. But the results have been different and difficult to dispute. Across the years these judgments span, India rose from among the bottom quarter of the World Bank's ease of doing business rankings into the top 100, and enforcing a contract in this country stopped being a byword for delay. To my mind, a courtroom that keeps its words quickly becomes a country the world is willing to trust with its capital. Ladies and gentlemen, at this juncture it is worth pausing on what this forum actually represents, because I suspect we undersell it. This gathering, as rightly pointed out by Mr. Naganand also very briefly, represents 11 legal traditions of common law and civil law, hybrid systems built on older customary roots, and learning to place trust in one another's institutions without first flattening our differences into sameness. That, to my mind, is a harder achievement than uniformity and a more durable one. This initiative is currently progressing within the framework of the bloc itself. The New Development Bank did not merely adopt a rule book from external sources. Rather, it developed its own rule-bound and multilateral, accountable to its own members instead of institutions designed for a different era. Such efforts also constitute institutional capacity building, which coincidentally aligns with the very theme selected by this forum. A gathering of this stature ought to leave behind more than well-chosen words, mine included. Let me modestly propose two things for this forum's consideration. First, a BRICS Plus judicial fellowship, allowing every career judge to sit very briefly in one another's courts. And second, a shared jurisprudence repository, drawing on India's own considerable investment in digitized case law, so that a judgment written in New Delhi or Brasilia or Pretoria need not wait years to inform a bench elsewhere facing an identical question. If there is one phrase you absorb into your vocabulary this morning, let it be Nyaya Setu, a bridge of justice that connects 11 legal traditions which have mutually agreed that trust should be cultivated deliberately rather than awaited positively or passively. Let me reiterate that the rule of law is the edifice upon which civilization construct their aspirations. It is the invisible thread that binds the hope of progress to the reality of justice. Economic resilience, like a sturdy tree weathering the tempests of global uncertainty, roots itself in predictability, fairness, and trust. Innovation, the spark that lights the corridors of our collective imagination, thrives when shielded by legal certainty. Sustainability, our solemn pact with generations yet unborn, demands that our legal systems evolve to safeguard not only markets but also nature and human dignity. The BRICS Plus legal forum is uniquely positioned to champion this vision. Together, we embody the dynamism of emerging economics and the wisdom of ancient civilization. Let us therefore commit to a future where institutions are not fortresses of formality but breezes of trust, where our united efforts illuminate a path of mutual harmony and prosperity. In closing, I extend my warmest congratulations to the organizers of this forum for maintaining over 11 editions, what many conferences claim but few accomplish. Furthermore, I commend the selection of this year's tectonic theme, one that is as timely as it is timeless. Let me end by asking each of you to carry one thought with you, that the strongest economies of this century will not be ones with the most resources beneath their soil, but the one whose courts and institutions honor every promise made above it. Thank you very much for inviting me, giving this opportunity to share my views. Thank you very much.
Thank you, Lordship, for this illuminating observation and giving us two new terms, the vocabulary that we will be deliberating on in the next 2 days and many more years to come, the Nyaya Setu and Nyayanomics. I think we are going to talk about it for a long time to come. Now, very quickly, as this many of you would know, today is a working day in the Supreme Court of India. So without wasting any further time, I would now request the learned Attorney General for India to kindly felicitate on our behalf to the Honorable the Chief Justice of India. Now may I request President Bar Association of India, Mr. Prashant Kumar, to kindly present his book to the Honorable the Chief Justice of India, and which can be unveiled. And I request Mr. Vinay Ahuja, the publisher, to be also join us on the dais. Requesting everybody to unveil the book. Thank you. Can we request everybody to please step up so that the picture can be clearer? Without any further delay, I am here to express all our gratitude to the Honorable the Chief Justice of India for having taken out the time to join us despite today being a working day in the Supreme Court of India. Let me inform that the Honorable the Chief Justice would be taking leave from us today, but as he asked all of us that all of you are not only our guests but his guests, we are truly honored to have you, sir. Thank you so very much.
Thank you.
Requesting all delegates to kindly be there in the hall and not leave the hall as we'll continue the proceeding for the day. I once again express our deep sense of gratitude to the Honorable the Chief Justice of India for inaugurating the BRICS Legal Forum that is hosted by the Bar Association of India. To continue the proceeding, now may I request the President Bar Association of India, Mr. Prashant Kumar, to kindly deliver his address.
Very good morning to all of you to this 11th BRICS Plus Legal Forum, and we have partner countries as well. Malaysia is represented apart from the BRICS Plus countries, and also we have a special guest, our delegates from Nepal, who are also here, because BRICS Plus, in my view, is the best guardian of interests of the entire global South, not just the member countries of BRICS Plus. Because it is not only that through this forum we establish a dialogue between 11 different legal traditions and
most of the members being old civilizations, each one having a unique history and unique place in history, which has contributed to the shaping of the modern world. Ladies and gentlemen, BRICS Plus is not a treaty organization. It is an organization found on the bonds of friendship, on the bonds of common interests, and the bonds of an agenda to see that the governance of the world is more balanced and more cognizant of the interests of the greater part of world's population, and foregrounding their concerns in terms of their economy, in terms of well-being of their populations, and in terms of challenges like climate change, global warming, and increasing global geopolitical friction. In all these things, if BRICS Plus stands together and each year is able to forge a common agenda, a common voice, and a common output in terms of shared declaration which everybody signs to, is by itself a clarion call to the entire humanity on this planet that yes, finally those who you call emerging have arrived, and they are there to claim their place in the global setup, in the global institutional setup, because you cannot be blind to the needs, requirements, and aspirations of the better part of the world. And here I just want to place one proposition. Our Chief Justice has given two very useful thoughts to take away, and that puts justice at the core of it. So I again put justice at the core of it, but in the economic sense, because BRICS Plus is after all taking forward an economic agenda. So in the economic sense, the globe cannot progress unless until there are more consumers, there are more people who are more well-resourced to buy goods and services, to afford goods and services. So this whole conception of the world coming out of poverty is no longer going to sustain the aspirations of populations who are now getting more literate, getting more connected. Digitalization is shrinking the world further, and there are better communications with the tools. And artificial intelligence, though it has concerns which are to be addressed, but also provides a tremendous scope for different people with different languages to be able to converse with each other in a much more easier manner than before. So, if you want to see a world divided between the developed countries and the developing countries, we must recognize that no developed country will remain developed and grow further unless until the populations of the global south and BRICS Plus are supporting it. We are the ones who are the engines of the global economy, not the aging populations, not the developing countries which have reached the saturation point. So, even for them to see that the BRICS countries grow, BRICS Plus countries grow and economically prosperous is in their own self-interest. If they are not able to do so, there is a myopia which has set in their thinking, because they are not able to see beyond their shores. But here, BRICS Plus connects all the major continents, all the major economies, and holds the key to the future of the humanity. And the Bar Association of India, my friends, is so honored to have all the top leadership of the BRICS Plus countries represented here, very actively participating. And two more announcements I want to make. We are very honored to have a lady lawyer, part of the delegation from Iran. It is so different from the usual picture of Iran, which is portrayed. So that is what BRICS is about. BRICS breaks boundaries. And each one of this, in this row and there, sits, stands, shakes hands as friends. The geopolitical and political dimensions may be different, but as lawyers, we share the same values. We share the same sentiments. We are all bound by the same sense of justice and the rule of law. That is what we share, and no geographical or physical boundary can separate this sentiment. We also have 54 countries of Africa represented by Mr. Tulu. He is the president of African Union's legal organization, which is Pan-African Lawyers Union. So the dialogue of BRICS and Africa is very important. And of course, our own Naganand represents, in a larger context, Asia Pacific, being the Vice President of Law Asia. So with this, I once again welcome each of our guests. I welcome all our delegates and participants. Hopefully, we will justify your 2 days of time spent here. Thank you.
Thank you, sir, for this, for sharing some of your thoughts. For anyone who is interested to know many more of his thoughts, I would urge you to read this book. If I can only read one paragraph that is here, I think that further contextualizes what we are discussing today. He says, the author says, Mr. Prashant Kumar, for a millennium, Indian commerce ran on an architecture of trust. The guilds, the hundi network, the merchant ethic inscribed in stone from Nagapattinam to Quanzhou, the Indian ocean trading economy built under the Cholas in the 1872 colonial codification severed contract law from that inheritance that we always had. Precise about the breach, silent about the conduct as it is, the result is a system in which the delay is rational. Opportunism carries no price and value is destroyed at the very moment cooperation would have been preserved. The cost compounds and it is paid by everyone who contracts. So I think these thoughts that the cooperation takes us to achieve collective goals. With that thought, now I request the Attorney General for India, Mr. R. Venkataramani, to kindly give his address.
We have a new wealth of nations assembling here. This is not Adam Smith's wealth of nations. I am so delighted to be here on behalf of the Bar Association of India, to be part of the congregation of dignitaries on the dais who have traveled long distances, but willing to travel more minds and ideas. And I welcome each and every one of them here on behalf of the Bar Association of India, on your behalf. And my respectful greeting to the Honorable Chief Justice, who was here with us, who spared his time and for public concerns and no time for his personal welfare. And I think Bar Association of India owes greatly to his warm presence. My warm greetings to Prashant Kumar and President Bar Association of India, and the entire BAI team, the architects of this conference. My greetings and warm regards to all the delegates and dignitaries from all over the world, and who have considered that there is a compelling need to gather and discuss the subjects we have chosen for our attention. The Bar Association of India deserves a great applause for carefully and imaginatively choosing the theme for the conference. This is keeping in tune with a slowly emerging understanding that we are running out of steam in working our many conventional propositions on common good. We are called upon to redefine common good, redefine national connectivities, and conceive the necessary inter-country common good cooperations, and within domestic frontiers, refashion our governance institutional structures. This call to engage in envisioning such global common interests is a call to turn a new chapter on rule of law. Probably I would like to expand BRICS as bringing a rule of law in consonance with social change. As we are moving into greater global connectivities, greater sharing of common global resources, greater technology shifts, fundamentally different from earlier machine ages, and the common urges to remove needless inequalities, we need to connect rule of law to all of them. Civilizations all over the world flourished because of innovations. Every innovation made anywhere were products of the innate human drive to explain the world, understand it, and bring forth something of utility and betterment of human affairs. All the machines we have made, the architects we have created, have made our lives different, from kitchen to laboratories and our wardrobes to leisure times. But our current engagement in non-physical space technologies and the great race to combine their fruits with financial baskets is a new facet of social motions. We are beginning to hear loud voices on the urgent need for regulation and accountabilities. Where does the rule of law figure here? Innovations are linked with individuals pursuing their own persuasions to make something or to create something. Self-interest, even of an elevated order, will necessarily figure here. The Pareto efficiency principle that individuals pursuing their own self-interest in competitive markets can give rise to the most efficient and welfare-maximizing outcomes has led to efficiency being understood in a rank utilitarian sense. Do we agree that an activity can be efficient if it enhances someone's welfare without making anyone else worse off? What is efficient in one sense of perspective can be disruptive or anti-common good in any other sense of perspective is the most challenging subject in our non-physical space technologies. I wish to place an observation that will be necessary to figure out the sub-themes and underlying threats in our major subject for discussion today. Economic resilience cannot be a new name for economic efficiency as understood in neoclassical economics. It must connote the ability of economic principles and their working in order that the perennial human demand for equal regard and equal satisfaction of needs are satisfactorily met. Constitutions, coupled with political philosophies, emphasize that we should be driven by objectives, premise on equality, liberty, and fraternity. As every country is becoming a melting pot of diversities, fraternity is becoming a challenging issue. But economics continue to reflect on the difficult marriage between welfare principles, efficiency grounded in Pareto thesis, and common good. A recent thought on common good economy says, I quote, while the term public good is often confused in lay terms with the concepts of common good, they are in fact fundamentally different. Public goods are just correction for something the private sector does not do. The common good is not a correction, but an objective that requires a radically different type of analysis, and I quote. On the one hand, we critique the state as a blind partner to markets. On the other hand, we also see the dichotomy between the market and the welfare state. We must overturn the assumption that individuals or entities who make or share all social resources, from goods to education, from health to migration, are incapable of or resistant to cooperation, but can also be required to actively engage in cooperation. A common good economy requires embedding economic objectives within the fabrics of social relationships and rethinking how all actors, individuals, public institutions, and private markets relate to one another. This demands removing from the notion of market failures. It must instead be about how to shape markets and the economy, putting the common good at the center of all economic relationships. To create a new economics of the common good, we must thus shift away from a focus on mere maximization exercise towards collective value creation, where interactions between business, government, and other organizations are viewed not as a mere quotes, Buddha-like, grapple with locating the middle paths. The wealth of nations no longer lie in the mere amount of goods we make. Our share markets themselves have become our common good. Within each nation, we have national interests and also sectional interests. How do we therefore redesign our goals, our means, our institutions in order that we can conceive a new Pareto common good efficiency? Where does capacity building come in the midst of all these? Capacity building of whom and how? Our governance and judicial institutions were designed to perform certain functions in certain ways. Both functions and ways are under stress and challenge. Both institutions must therefore must open up their doors and windows. Courts must be willing students and institutions must become willing cooperators. The legal profession cannot be a mere witness to all these. We are thus assembled here today, probably to raise us income to answer a common good call. What responsibility the next generation of rulers should bear, and what inter-country common goods connections can make technologies servants of non-destructive welfare. These are matters of civilization concern, and who else but the legal community can sound the bugles. Let us pledge ourselves to be explorers beyond Columbus. I invite once again, all of you assembled here today for a very profound exchange of ideas, and I'm sure the 11th BRICS Plus Legal Forum envisioned by Barata Association of India will become a global attention in times to come. I wish every one of you a great stay in Delhi.
Thank you, sir. Now, as we move on to the addresses by the head of the delegation, I take this opportunity to call upon Mr. Wang Hongxiang. Please pardon me for the mispronunciations, if any. The Executive Vice President, China Law Society, to kindly address the session. He is also the Secretary of the Communist Party of India Central Committee. Mr. Wang, please.
尊敬的文卡特拉玛尼 总检察长，尊敬的Prashant Kumar 主席，金砖各国代表团团长，女士们、先生们、朋友们，大家上午好。在这美好的季节，我们相聚在生机盎然的新德里，共同出席第11届金砖国家法律论坛。这是论坛迎来的第12年，是论坛第2次走进印度，也是我本人第1次参加论坛，我充满期待。在此，我仅代表中国法学会，代表中国全体法学法律界的同仁，向论坛的召开表示热烈的祝贺，向印度律师协会为这次论坛所做的精心组织安排表示诚挚的感谢。全球南方的现代化事业提供了清晰的战略指引和行动框架。全球南方国家的群体性的崛起，是世界大变局的鲜明标志，打破了现代化等同于西方化的单一模式。全球南方国家，我们一起共同迈进现代化，是世界历史上的一件大事，也是人类文明进程中的史无前例的壮举。金砖合作机制诞生于全球南方群体崛起的历史浪潮之中，是当今世界最重要的新兴市场国家和发展中国家的合作平台。从2026年诞生至今，金砖合作机制已走过了20个春秋，同行的伙伴们越来越多，合作的道路越走越宽广。从金砖4国到金砖5国，从金砖加到大金砖合作，从正式成员到加入了伙伴国，金砖国家在不断深化合作机制建设的同时，强化南南合作网络，已经成为团结全球南方、完善全球治理和推进世界多极化的中坚力量。扩大成员后的金砖大家庭，拥有了11个的正式成员国和10个伙伴国，总人口超过了世界人口的1半。我们聚集了大富矿、大工厂、大市场， 经济总量占全世界近30%，成为全球南方的第一方阵。越来越多的新兴市场国家和发展中国家渴望走进金砖，申请加入的等候名单不断的扩大，大金砖的合作已经驶入了快车道。下个月，金砖国家的领导人将在印度举行第18次会晤，进一步的推动金砖合作的历史进程。金砖国家的合作越紧密，我们应对外部风险挑战的底气就越足，办法就越多，效果就越好。中方愿同金砖各国一道，开展大金砖合作高质量发展的新局面，携手更多的全球南方国家，共同推动构建人类命运共同体。女士们、先生们、朋友们，新时代新征程，中国继续书写经济快速发展和社会长期稳定的2大奇迹的新篇章。2021年到2025年这5年间，中国的国内生产总值接连迈上了110万亿到140万亿人民币的总量的台阶，经济体量实现了跨越式的提升。中国稳居全球第2大经济体，经济的总规模已经接近了全球第3位到第7位国家的经济总量之和，每年为全球经济的增长贡献了近30%的增长动力。 本届论坛又迎来了许多的新成员国和伙伴国的法律界的同行朋友。在此，我诚挚地欢迎各位加入金砖法治合作的大家庭。在中国传统文化中，每12年称作一轮，寓意着承先启后，继往开来。我们站在新一轮合作的更高的起点和平台上，金砖国家的法学法律界面临着前所未有的历史机遇，大有可为，未来可期。中国法学会愿同各方新老朋友一起，进一步密切在金砖国家法律论坛平台上的协调与配合，团结全球南方法学法律界，放大全球南方的法治声音，共谋大金砖格局下法治合作的新路径。律师们、先生们、朋友们，本届论坛我们将围绕增强经济韧性、驱动创新与可持续发展的法律制度建设这一主题开展深入研讨，共同探索如何在多极化的世界中用法治凝聚共识，推动经济复苏和稳定发展，可谓正当其时，意义深远。国际社会的力量对比正在深刻的演变，但全球治理体系的改革却长期滞后，全球南方国家的声音尚未得到充分的体现。我们金砖国家要坚持弘扬开放包容、合作共赢的金砖精神，携手践行真正的多边主义，坚持共商共建共享的全球治理观，在汇聚南南合力上拿出我们更大的作为，争当推进全球治理体系变革的先锋力量，为提升发展中国家在全球治理中的代表权和发言权做出我们积极的贡献。我们金砖国家的法学法律界更应当同心携手，积极吸纳更多的成员国和伙伴国参与金砖法治合作机制，加强同广大新兴市场国家和发展中国家的法学法律机构的合作交流对话，打造大金砖法治合作的平台，共同搭建适应世界多极化、经济全球化、创新可持续发展的法律保障，打破由少数国家主导的旧的治理规则。我相信本届论坛一定能够凝聚丰富的务实的法治合作成果，在金砖国家的法律论坛的历史上留下浓墨重彩的新德里印记。在此，我愿提出4点建议，与各金砖国家法学法律界的同行来交流。第一，以金砖法治担当破解全球发展格局。当前，多边贸易体制遭受冲击，全球经济复苏步履维艰。金砖国家的法学法律界要以维护以世界贸易组织为核心的多边贸易体制，致力于构建开放性的世界经济，旗帜鲜明地反对单边主义和保护主义，维护产业链、供应链的稳定畅通，将促进发展置于我们合作议程的中心位置。要持续构建金砖国家争议解决机制，依托已有的上海、新德里2大中心，加快布局 其余成员国的网点，早日建成金砖国家全覆盖的争议解决网络，切实守护全球南方经贸主体的合法权益，积极推动完善金砖国际投资相关法律规则，深化与新开发银行的合作，以金砖法治担当，努力为新兴市场和发展中国家营造稳定、公平、可预期的法治营商环境，促进各国经济复苏和发展。第二 ，second， 以金砖法治智慧完善新兴领域治理，新一轮科技革命和产业革命加速突破，全球人工智能技术创新进入了前所未有的活跃期。AI 正在赋能千行百业，惠及千家万户。金砖各国的法学法律界要紧跟时代步伐，坚持发展和安全并重，常态化的开展政策研讨、能力建设和最佳实践的交流，持续健全数字创新领域的治理规则，保障人工智能安全可靠、合规可控。期待各位同行围绕本届论坛的人工智能治理议题充分交流，畅所欲言，集思广益，凝聚形成金砖国家的人工智能治理的共识，用金砖法治智慧护航创新金砖高质量发展。第三，以金砖法治共识践行绿色可持续发展。绿色是这个时代的底色，金砖国家要主动融入全球绿色低碳转型洪流。中国的电动汽车、锂电池、光伏产品等优质产能，为世界绿色发展提供了重要的动能。金砖国家的法学法律界要积极融入各国的绿色产业、清洁能源以及绿色矿产合作，恪守共同但有区别的责任准则，依托新开发银行、国际太阳能联盟等，推动完善气候融资、清洁能源技术转让的配套法律规则，兼顾商业权益与发展正义，以可持续发展的共识为建设绿色金砖贡献法治力量。第四点建议，也是最后一点建议，以金砖法治行动加快论坛机制的建设。在主办方的大力推动下，本届论坛有望纳入今年金砖国家峰会的整体议程。我们要乘势而上，加快设立线上常设秘书处以及专业工作组，着力推进论坛机制建设走深走实，逐项落实历届论坛形成的宣言共识，做事做细，落地见效，以务实行动将各项共识转化为实实在在的合作项目，让金砖法治合作的成果惠及到每一个金砖成员国和伙伴国，携手推动大金砖的合作不断的迈上新台阶。女士们、先生们、朋友们，小船孤篷经不起惊涛骇浪，同舟共济方能行稳致远。金砖国家的法律体系各不相同，但是基于追求共同的目标走到一起，我们是志同道合、休戚与共的好伙伴、好朋友。 让我们求同存异，携手并肩，守望相助，重温金砖国家法治论坛成立的初心，从新德里再出发，顺应全球南方崛起的大趋势，支持帮助更多的新兴国家和发展中的国家投身金砖法治合作的事业，汇聚全球南方的法治合力，共同为世界的和平稳定汇入金砖法治的正能量，携手开创大金砖法治合作的美好未来。最后，衷心祝愿本届第11次金砖国家法律论坛圆满成功。谢谢大家 ，Thank you， 谢谢。
Thank you, Mr. Wong. Most of you had the simultaneous interpretation equipment. In case you did not have, the transcription is actually ready. It will be emailed to all the delegates for your benefit. Now may I request the President, Bar Association of India, to kindly felicitate the Attorney General as he is about to leave. Thank you, sir, for being with us this morning. We once again express our gratitude to the learned Attorney General for being with us. To continue the proceeding, can I now call upon the President of the National Commission for Foreign Affairs, Secretary of the Executive Committee of the BRICS Legal Forum of the OAB, Mr. Bruno, to kindly deliver his address.
Good morning, Namaste. President of the Bar Association of India, my good friend Prashant Kumar, Honorable Attorney General that just left our event, heads of delegation, also very good friends, all colleagues of BRICS plus legal community. It is an honor to speak on the behalf of the Brazilian legal profession. Let me begin with our hosts. India has received this forum with the generosity for which this country is known, and has given us a theme that could not be more precise for our moment: resilience, innovation, cooperation, and sustainability. To the Bar Association of India and to the chairship that has carried this agenda through the year, our sincere thanks. Now, if I may, let's look around this room. The jurisdictions gathered here account for a very large share of humanity. Among us are codified traditions and case law traditions, systems shaped by statute and systems shaped by custom, some of the oldest legal cultures on this earth and some of the newest constitutional texts. We were not built from a single template. I would suggest that this is not our difficulty, it's our strength. And what we hold in common is more decisive still. We are societies of scale with plural populations and with development agendas that will not wait. Each of us has entrusted the defense of rights to courts and to an organized, self-governing legal profession. So, when the lawyers of our countries sit at the same table, we discover very quickly that we already speak the same language, even before the interpreters begin. Allow me a word of memory. This forum was born in Brasilia, the capital of Brazil, in 2014. 11 years later, in Rio de Janeiro, we welcomed a forum that had grown from an idea to an institution. Today, it arrives in New Delhi broader than it has ever been, with more jurisdictions at this table than any of its founders imagined. Brazil takes this year's theme personally, because we have learned sometimes the hard way that resilience is not built by decree, it is built by institutions, and the most patient builder of institutions is the lawyer. Let me say plainly what Brazil believes. Trade agreements are signed by governments. Investment is decided in boardrooms, but none of it survives contract with reality unless something sits underneath it. Predictable rules, contracts that mean what they say, disputes resolved by neutral hands, and the legal profession independent enough to say no when no is the correct answer. That is what we are here to build, not sentiment, but infrastructure, legal infrastructure, arbitration our companies can actually use, mediation that prevents the dispute before it becomes one, the patient study of another legal systems so that a lawyer advising on a transaction in a partner jurisdiction is not working in the dark. And this infrastructure cannot be built only for the largest firms and the largest clients. A framework that serves only the powerful is not cooperation, it's a club. Brazil will always argue for the small and medium enterprise, for the sole practitioner, for the young lawyer in a city far from the capital. Which brings me to the question that no legal profession on this planet can now avoid: artificial intelligence. Colleagues, AI has already entered our offices. It is drafting, summarizing, researching, predicting. The question is no longer whether it arrives. The question is on whose terms. Brazil's position is that this technology must be governed, not feared and not worshipped. Governed by human oversight at the center, with professional confidentiality intact, with client data protected, with the independence of the lawyer preserved, and with a clear answer to the hardest question of all: who is accountable when the machine is wrong? But governance without capacity is an empty promise. You cannot ask a profession to use a tool responsibly if you are never taught it how the tool works. So the Brazilian Bar Association has taken a decision whose scale I want to share with you. The OAB, the Brazilian Bar Association, has launched a national plan for the integration of artificial intelligence into the legal profession, a program reaching nearly 1.5 million Brazilian lawyers. 1.5 million. Through our National School of Advocacy and our schools in every state of the Federation, with governance and ethics as the first pillar, not an afterthought, and with one objective above all: to make certain that the distance between the large firm and the lawyer working alone narrows instead of widening. We do not present this as a finished model. We present this as an experience, one that Brazil offers openly to every jurisdiction in this room. And we ask, with equal sincerity, to learn from yours. Distinguished colleagues, what we say in this hall over the next 2 days is word on a paper. What gives those words their weight is what each of us does on the morning after we fly home. Brazil came to Delhi to work, and Brazil will go home to work. Thank you. Obrigado. Dhanyavad.
Thank you so much. Now may I request the President, Ethiopian Federal Advocates Association, Mr. Tasfe, to kindly deliver his address.
Mr. Prashant Kumar, President of the Bar Association of India, distinguished leaders of bar associations and legal institutions, senior advocates and fellow delegates, ladies and gentlemen, Namaste and warm greetings from Ethiopia, the land of origins. It is my honor and privilege to address the 11th BRICS Legal Forum on behalf of the Ethiopian Federal Advocates Association. Allow me first to express my sincere appreciation to the Bar Association of India for bringing us together here in New Delhi, and for the care, hospitality, and excellent organization of the forum. Ethiopia comes to this forum as a country with an ancient history, a living tradition of independence, and a deep commitment to African solidarity. Addis Ababa, our capital, is the diplomatic capital of Africa and the seat of African Union. Our experience has taught us that diversity need not prevent unity, and those sovereign nations can cooperate without surrendering their distinct histories, identities, and legal traditions. Our legal systems are not identical, nor do they need to be. They arise from different histories, constitutional arrangements, and social realities. Our task is not to erase those differences, but to build the trust, compatibility, and historical cooperation that allow systems to work effectively together. This year's theme, Rule of Law, Frameworks and Institutional Capacity Building for Economic Resilience, Innovation and Sustainability, speaks directly to that task. Political declarations can open doors, but lawyers and legal institutions must build the pathways through them. Trade, investment, innovation, and development cannot rest on goodwill alone. They require predictable laws, credible institutions, enforceable agreements, accessible dispute resolution mechanisms, and independent legal professionals. The true value of this forum will be measured not only by the quality of our discussions or language of our declaration, but by what follows, whether we sustain the networks we create, strengthen institutional capacity, develop practical frameworks, and open meaningful opportunities for the next generation of lawyers. For the Ethiopian Federal Advocates Association, participation in this forum is both an honor and responsibility. Established by law in 2021, EFA is one of the youngest national bars represented here. We come with the energy of a young institution and with the humility, ready to learn from associations with decades of experience while sharing our own journey of building a national statutory bar almost from the ground up. As many of you know, Ethiopia is the birthplace of coffee. In our tradition, coffee is shared in 3 rounds. Abol, Bona, and Paraka, they are called, creating time for conversation, respect, and human connection. In the same spirit, this forum gives our legal communities the space to listen, understand one another, and turn dialogue into lasting trust. I hope this 11th BRICS Legal Forum will mark a further step from dialogue to delivery, from shared aspirations to durable institutions, and from professional acquaintance to genuine legal cooperation. I wish you all productive deliberations. Thank you so much.
Thank you so much. Now I request Dr. Hassan Abdulyanpour, President, Center of Attorneys, Official Experts, and Family Advisors of Judicial Power, to kindly deliver his address.
بسم الله الرحمن الرحیم. عالی جنابان، رؤسای محترم، مدیران کانونهای وکلا، قضات ارجمند، همکاران گرامی، صاحب نظران فرهیخته، خانمها و آقایان، با تقدیم سلام و نهایت احترام، خرسندم که در این رویداد مهم حقوقی در پایتخت تاریخی و تمدنی جمهوری هند در کنار همکاران گرانقدر خود از کشورهای عضو و دوست بریکس حضور دارم. در آغاز مراتب سپاس و قدردانی عمیق خود را از کشور دوست و بزرگ هند، کانون وکلای دادگستری هند و جناب آقای پرشانت کمار و ریاست محترم کانون وکلای دادگستری هند به خاطر میزبانی شایسته، سازماندهی حرفه‌ای و فراهم کردن این فرصت ارزشمند برای گفتگوی حقوقی میان ملت‌ها اعلام می‌کنم. برای ما حضور در دهلی نو تنها شرکت در یک نشست حقوقی نیست، بلکه فرصتی است برای بازاندیشی درباره این پرسش بنیادین که آیا می‌توان جهانی را ساخت که در آن قدرت تابع قانون باشد و نه قانون تابع قدرت؟ من باور دارم پاسخ ما باید روشن باشد. آری، و شاید یکی از مهمترین رسالت‌های بریکس در قرن 21 کمک به تحقق همین آرمان باشد. عالی جنابان، اجازه دهید در این نقطه با حفظ فضای سازنده این اجلاس به یک اصل بنیادین حقوق بین الملل اشاره کنم. منشور ملل متحد در ماده 2 بند 4 اصل منع توسل به زور علیه تمامیت ارضی یا استقلال سیاسی دولت‌ها را به عنوان یکی از پایه‌های نظم بین‌المللی تثبیت کرده است. ما در جهانی زندگی می‌کنیم که متاسفانه هنوز جنگ، تحریم، حمله به زیرساخت‌ها و آسیب به غیر نظامیان واقعیت دارد و جمهوری اسلامی ایران در سالهای اخیر از جمله در جریان تجاوز نظامی اخیر ایالات متحده آمریکا و رژیم اسرائیل خود را در برابر یک تجربه بسیار تلخ یافته است. ما امروز به اینجا نیامدیم تا اختلافات سیاسی را به این سالن منتقل کنیم، بلکه آمده ایم تا حقوق را بالاتر از سیاست قرار دهیم. جنایات واقع شده بر مدرسه شجره طیبه میناب و ورزشگاه لامرد برای مردم ایران فقط یک واقعه تلخ ملی نیست. برای ما یادآور شکستن این اصل انسانی است که کودکان، مدارس، مراکز درمانی و زیرساخت‌های حیاتی غیر نظامی باید از حمایت حقوق بین الملل بشردوستانه برخوردار باشد. آیا ما به عنوان خادمان عدالت می توانیم بپذیریم محل برقراری عدل و داد و احقاق عدالت مورد تهاجم و تجاوز نظامی قرار گیرد؟ آیا تجاوز به ساختمان دادگستری لار که در ساعات کاری مورد حمله مستقیم موشکی قرار گرفت و منجر به شهادت 2 قاضی، 3 وکیل و 2 کارشناس رسمی دادگستری و تعدادی از مراجعین به محکمه گردید، در کنار حمله به مجموعه اداری ما، مرکز وکلا، کارشناسان رسمی و مشاوران خانواده قوه قضاییه، به عنوان یکی از اعضای فروم حقوقی بریکس در تهران قابل پذیرش است؟ آیا دادگستری‌ها جز محلی برای استیفای حقوق مردمان مظلوم هستند و خواهند بود؟ تاریخ چه قضاوتی درباره سکوت و بی‌تفاوتی نسبت به این جنایت خواهد داشت؟ کنوانسیون‌های ژنو 1949 و پروتکل الاغی اول 1977 در کنار اصول مسلم حقوق بین الملل بشردوستانه بر حمایت از جمعیت غیر نظامی و تمایز میان اهداف نظامی و غیر نظامی تأکید دارند. بنابراین موضع ما علیه یک ملت نیست، موضع ما علیه مردم آمریکا یا مردم هیچ کشور دیگری نیست. موضع ما علیه بیقانونی حاکمیت‌های یاغی و قانون شکن است. ما با احترام به ملت‌ها در برابر هر اقدامی که حقوق بین الملل، حیات انسان‌ها و کرامت غیر نظامیان را تهدید کند ایستاده ایم. ما از کتاب آسمانی خود قرآن کریم آموخته ایم که در حق دشمنان ما نیز نباید بی‌عدالتی روا داریم. ولا یجرمنکم شنعان قوم علی الا تعدلوا اعدلوا و اقرب للتقوی. این برای ما یک اصل عمیق حقوقی و اخلاقی است. عدالت باید عدالت باقی بماند، حتی زمانی که با هم اختلاف نظر داریم. ما همچنین معتقدیم امنیت پایدار در هیچ منطقه‌ای با حضور دائمی قدرت‌های خارجی و نظامیگری حاصل نمی شود. راه آینده گفتگوی منطقه‌ای، احترام متقابل، حاکمیت دولت‌ها و ایجاد سازگار امنیتی و حقوقی توسط کشورهای هر منطقه و برای کشورهای همان منطقه است. ما از این تریبون نه دعوت به تقابل بلکه دعوت به مسئولیت پذیری مشترک می‌کنیم. بیایید جهانی بسازیم که در آن اختلافات با مذاکره حل شود، قراردادها با داوری حل و فصل شوند، اختلافات تجاری با میانجیگری مدیریت شوند و هیچ کودکی قربانی محاسبات قدرت‌های بزرگ نشود. این همان جایی است که بریکس می‌تواند نقش تاریخی خود را ایفا کند. اگر آنچه برای ما اتفاق افتاد برای شما اتفاق بیفتد، توقعتان چیست؟ امروز باید همان وظیفه و توقع را در حق ایران و ایران قدرتمند اجرا کنید، چرا که تاریخ با چشمانی باز همه ما را قضاوت می کند و اگر پاسخی درستی به این قانون شکنی ها و جنایت علیه بشریت داده نشود، این جنایتکاران دیر یا زود به سراغ تک تک ملت‌های آزاده جهان خواهند رفت و نقشه چپاول ثروت‌ها و کشتن فرزندانشان را خواهند کشید و آن روز فریاد دادخواهی هیچ کداممان به جایی نخواهد رسید. عالی جنابان، همکاران ارجمند، از آنچه گفته شد علاوه بر توقع حمایت و همراهی در دفاع از ملت مظلوم اما مقتدر ایران بر یک معنای مهم تکیه می کنم. بریکس صرفاً یک سازوکار اقتصادی نیست. بریکس در روند تکامل خود به یکی از مهمترین بسترهای تعامل میان تمدن‌ها، اقتصادهای نوظهور و کشورهای مستقل جهان تبدیل شده است. اما توسعه اقتصادی بدون امنیت حقوقی، عدالت قضایی، پیشبینی پذیری حقوقی و حاکمیت قانون پایدار نخواهد بود. از این رو ما باید به یک سمت معماری حقوقی بریکس حرکت کنیم، معماری که مکمل نظام‌های حقوقی ملی و بر اصول مشترک استوار گردد. حاکمیت قانون، استقلال قضایی، احترام به حاکمیت دولت‌ها، برابری حاکمیتی، حل مسالمت‌آمیز اختلافات، احترام به حقوق بشر و کرامت انسانی. من معتقدم آینده همکاری حقوقی بریکس باید از مرحله گفتگو عبور کرده و به مرحله نهادسازی و تولید ظرفیت مشترک حقوقی برسد و در این راستا پیشنهاد می کنم این مجمع علاوه بر بیانیه‌های سیاسی به یک نقشه راه حقوقی بریکس بیاندیشد. نقشه راهی با چند هدف مشخص: 1. ایجاد شبکه داوری و میانجیگری بریکس. اقتصادهای بزرگ به سازوکارهای بزرگ حل اختلاف نیاز دارند. پیشنهاد مشخص ما توسعه یک شبکه داوری و میانجیگری بریکس است، شبکه‌ای برای داوری تجاری بین‌المللی، سرمایه‌گذاری، قراردادهای دولتی و میانجیگری فرامرزی. این سازوکار می‌تواند با احترام به صلاحیت و استقلال مراکز داوری ملی موجود، زمینه همکاری و تبادل داور، استانداردهای حرفه‌ای، آموزش و شناسایی متقابل ظرفیت‌های داوری را فراهم کند. در آینده می‌توان به ایجاد سازوکارهای مشترک برای حمایت حقوقی از سرمایه‌گذاری و تجارت میان کشورهای عضو اندیشید و درباره تأسیس یک مرکز داوری و میانجیگری بریکس گفتگو کرد. 2. آموزش و پژوهش مشترک. حقوق بدون دانش مشترک همکاری پایدار ایجاد نمی شود. پیشنهاد من ایجاد بریکس لگال اکادمی یا آکادمی حقوقی بریکس است با دوره‌های مشترک برای وکلا، قضات، داوران و پژوهشگران. همچنین ایجاد بانک داده و کتابخانه‌های دیجیتال حقوقی بریکس، برنامه‌های مشترک دکترا و پسادکترا، فرصت تبادل تجربه قضات، وکلا، داوران و اساتید دانشگاه، دوره‌های تخصصی حقوق تجارت بین‌الملل، حقوق سرمایه‌گذاری، داوری بین‌المللی، حقوق فناوری و هوش مصنوعی، حقوق بشر، حقوق انرژی و محیط زیست و حقوق بین‌الملل عمومی. و در کنار آن تأسیس یک بریکس لا جورنال با استانداردهای علمی و پژوهشی بین‌المللی. نشریه‌ای که نه متعلق به یک کشور بلکه متعلق به گفتگوی علمی میان نظام‌های حقوقی بریکس باشد. 3. وکالت تخصصی بریکس. جهان امروز به وکیل عمومی کمتر و به وکیل تخصصی بیشتر نیاز دارد. پیشنهاد می‌کنم در آینده با حفظ صلاحیت‌های ملی کانون‌های وکلا امکان طراحی یک نظام وکالت تخصصی بررسی شود. وکالت تخصصی در حوزه‌های مانند داوری بین‌المللی، تجارت و سرمایه‌گذاری، انرژی، فناوری، هوش مصنوعی، جرایم سایبری، حقوق بانکی، حمل و نقل بین‌المللی و حقوق بشر. این امر می‌تواند به تدریج یک جامعه حرفه‌ای جدید از وکلای متخصص بریکس ایجاد کند. 4. گردشگری حقوقی و علمی. ما می‌توانیم مفهوم جدید را به دنیا هدیه کنیم. دانشجویان، اساتید دانشگاه، وکلا، قضات و پژوهشگران کشورهای عضو بریکس بتوانند در دوره‌های مطالعاتی بازدیدهای علمی از دادگاه‌ها، مراکز داوری، دانشگاه‌ها و مؤسسات حقوقی کشورهای عضو شرکت کنند. این امر تنها گردشگری نیست، گردش دانش، تجربه و اعتماد میان ملت هاست و این رویای دست نیافتنی نیست بلکه پروژه هایی هستند که می توانند از امروز آغاز شوند. من از سرزمین ایران آمدم، سرزمینی با هزاران سال تمدن، قانون، دانش و تعامل میان فرهنگ‌ها و امروز در هند ایستادم، سرزمینی که خود یکی از تمدن‌های بزرگ تاریخ بشریت و یکی از قطب‌های مهم حقوق، دانش و توسعه در جهان معاصر است. میان ایران و هند تنها روابط سیاسی و اقتصادی وجود ندارد بلکه میان دو تمدن و کشور بزرگ یک حافظه تاریخی از گفتگو، تجارت، دانش و احترام متقابل وجود دارد. گاندی رهبر بزرگ هند جمله‌ای دارد که برای این اجلاس بسیار الهام بخش است. Peace is its own reward. صلح خود بزرگترین پاداش است. و سعدی شاعر بزرگ ایران قرنها پیش گفت بنی آدم اعضای یکدیگرند، بنی آدم اعضای یک پیکرند که در آفرینش ز یک گوهرند. این دو نگاه از دو تمدن بزرگ در یک نقطه به هم میرسند. انسان پیش از آن که تبعه یک دولت باشد صاحب کرامت است. پس بیایید بریکس را تنها به یک ساختار اقتصادی قدرتمند تبدیل نکنیم. بیایید آن را به یک فرایند حقوقی قدرتمند، مسئول و اخلاق مدار نیز تبدیل کنیم. ساختاری که در آن قدرت با قانون محدود شود، اختلاف با گفتگو حل شود، سرمایه با امنیت حقوقی حرکت کند، دانش آزادانه میان ملت‌ها جریان یابد و کرامت انسان خط قرمز مشترک همه ما باشد. از جمهوری اسلامی ایران دست دوستی، همکاری و گفتگوی حقوقی را به سوی همه کشورهای حاضر در این اجلاس دراز می کنم و بار دیگر از کشور بزرگ هند، کانون وکلای دادگستری هند و جناب آقای پرشانت کمار، ریاست محترم کانون وکلای هند برای این میزبانی شایسته و این فرصت ارزشمند سپاسگزارم. امیدوارم دهلی نو در سال 2026 نه فقط میزبان یک مجمع حقوقی بلکه نقطه آغاز نسل جدیدی از همکاری حقوقی و قضایی در جهان بریکس باشد. زنده باد همکاری بین‌المللی، زنده باد حاکمیت قانون و بالاتر از همه زنده باد کرامت انسانی و عدالت انسانی. السلام علیکم و رحمت الله و برکاته.
Thank you so much. Now I request Mr. Oleg Zetsev, Judge of the Economic Court of the Commonwealth of Independent States, member of the Presidium, Association of Lawyers of Russia, Dean of the School of Law, Presidential Academy and Doctors of Law, Professor, to kindly deliver his speech.
Thank you very much. Dear colleagues, dear Mr. Kumar, dear distinguished guests, сегодня я буду говорить по-русски. И рад вас приветствовать на 11-м юридическом форуме BRICS+. И в первую очередь хотел бы передать участникам форума слова приветствия от председателя Ассоциации юристов России Сергея Степашина, который поддержал проведение мероприятия в формате BRICS+, и выразил признательность Ассоциации юристов Индии за организацию форума в Нью-Дели. В этом году в состав делегации Ассоциации юристов России вошли более 19 человек. Это представители Министерства юстиции, Федеральной службы судебных приставов Российской Федерации, юридических вузов и факультетов нашей страны, МГИМО МИД России, Московского государственного юридического университета, Санкт-Петербургского государственного университета, Президентской академии, также Республиканского научно-исследовательского института интеллектуальной собственности, Российской арбитражной ассоциации и адвокатского сообщества. Я являюсь судьей Международного суда, экономического суда Содружества независимых государств и передаю слова приветствия участникам форума от имени председателя суда Германа Нурбаева. Экономический суд СНГ создан бывшими республиками Советского Союза и является международным судебным органом, рассматривает споры только между государствами, а также осуществляет толкование международных договоров стран СНГ. Потенциал суда позволяет говорить о возможности его развития, в том числе в рамках взаимодействия BRICS+. Отмечу, что Россия придерживается позиции формирования справедливой многополярной архитектуры мира на основе международного права, и ни один из его институтов не должен использоваться как юридическое оружие, но как юридическое средство объединения и взаимодействия. Юридический форум БРИКС является уникальной площадкой, которая объединяет юристов всех профессий. В 2024 году состав наших участников расширился, и мы поддерживаем интеграцию Ассоциации юристов из стран-партнеров БРИКС и развивающихся стран в работу форума. Приветствуем установление сотрудничества участниками форума с юридическими ассоциациями на пространстве ШОС, СНГ, АСЕАН, Африканского союза и других интеграционных объединений. В июне этого года в Санкт-Петербурге прошел 14-й Петербургский международный юридический форум, в котором приняли участие президент Ассоциации Индии Прашант Кумар, а также делегации Китайского юридического общества Южной Африки, Египетской ассоциации адвокатов, Ассоциации юристов Вьетнама, Белорусского республиканского союза юристов. Выражаем благодарность за ваше участие в работе форума и вклад в развитие правового сотрудничества по линии BRICS+. По линии BRICS+ ведется работа по обмену мнениями в области уголовно-правового сотрудничества. В июне этого года в Москве состоялся семинар по теме противодействия политизации международного сотрудничества в уголовно-правовой области. В нем приняли участие представители государств и участников БРИКС. Состоялся углубленный обмен мнениями по различным аспектам взаимодействия правоохранительных органов на профессиональной основе в интересах борьбы с преступностью и повышения безопасности граждан всех участвующих государств. Затрагивались также отдельные вопросы, связанные с политизированной деятельностью Международного уголовного суда. Особое внимание было уделено практике применения норм обычного международного права об иммунитетах должностных лиц государств от иностранной и международной уголовной юрисдикции. Считаем, что необходимо продолжить юридическую работу в области защиты иммунитетов высших должностных лиц государств в двухстороннем формате и в рамках BRICS+, а также по линии ООН и ее комиссии международного права. Нужно отметить и возможности, а самое главное результаты, которые дает юридический форум BRICS+, для двухстороннего взаимодействия наших органов государственной власти. Отмечу концепцию Министерства юстиции России и Санкт-Петербургского государственного университета о создании Международного инвестиционного арбитражного центра БРИКС. Ведение дискуссий среди юридических сообществ и экспертов на эту тему представляется важным. Благодарим за организацию отдельной дискуссии по этой теме. Активно развивается взаимодействие органов принудительного исполнения наших стран. Для эффективного противодействия вызовам современности необходимо полномасштабное межстрановое сотрудничество. И Российская Федеральная служба судебных приставов также активно диверсифицирует формы взаимодействия, переходя от традиционных двусторонних контактов к созданию устойчивых многосторонних платформ. Здесь интересен международный опыт нашей службы, которым можно воспользоваться и нам, участникам юридического форума BRICS+. Так, при поддержке Исполнительного комитета Содружества независимых государств ведется работа по созданию Совета руководителей органов принудительного исполнения. И данная площадка призвана объединить усилия стран Содружества и оставаться открытой для присоединения представителей любого государства мира. В качестве одной из важнейших стратегических целей в этой области мы видим наращивание контактов, развитие связи со странами БРИКС и выражаем свою открытость к диалогу и взаимодействию. Формирование специализированной рабочей группы нашего форума с включением в ее состав глав органов принудительного исполнения стран БРИКС+, придало бы совместной деятельности глобальное измерение. Предлагаю обсудить такие возможности на полях форума и на следующем форуме, принять решение в случае поддержки такой инициативы. Совместные усилия служат фундаментом эффективности национальных систем исполнения судебных решений. Это важный индикатор справедливого правового государства. Решения, принимаемые на наших форумах, должны развивать ранее принятые механизмы, в том числе в формате рабочих групп. В частности, речь идет о рабочей группе по интеллектуальной собственности, которая обсуждалась на 8-м юридическом форуме БРИКС в городе Йоханнесбурге в 2023 году. Наша миссия как профессиональных организаций юристов, формирование правовой культуры и повышение статуса юридической профессии. Ассоциация юристов России стала площадкой для профессионального диалога юристов всех сфер – судей, прокуроров, адвокатов и нотариусов. Особое внимание мы уделяем качеству юридического образования. На Ассоциацию юристов возложено проведение общественной аккредитации образовательных учреждений, осуществляющих подготовку юридических кадров. Важно понимать, что российские вузы проводят регулярный обмен опытом с вузами стран БРИКС в данной сфере. Ведется разработка совместных образовательных программ как на уровне государственных вузов, так и по линии частных образовательных учреждений. Наши студенты-юристы – это наше юридическое будущее. Это наша главная интеллектуальная инвестиция. Их вовлеченность в наши взрослые процессы обеспечит необходимую преемственность. В своем выступлении на сессии по юридическому образованию я подробно расскажу о проекте «Легаториум» как возможности формирования единого студенческого правового сообщества. Сегодня многие споры продолжают разрешаться в зарубежных юрисдикциях, а не в юрисдикциях стран БРИКС+. Мы считаем разумным формирование арбитражного механизма внутри объединения и развиваем инициативы по обучению арбитров из стран БРИКС+, для бизнеса БРИКС+. Это ускорит процессы и сократит расходы, обеспечит беспристрастность в рассмотрении дел. В связи с этим призываем коллег по нашему форуму к активному участию в работе над созданием собственной арбитражной сети. В кулуарах форума с коллегами мы уже обсудили создание Международной арбитражной академии БРИКС+. Специально отмечу здесь инициативу Ассоциации юристов России по созданию международного реестра юристов для нашей быстрой коммуникации и взаимопомощи. И у нас есть очень конкретный результат нашего взаимодействия. Буквально перед форумом мы получили из типографии учебник по адвокатуре, авторами которого являются руководитель Ассоциации юристов Индии господин Прашант Кумар и руководитель Ассоциации юристов Бразилии господин Bruno Barata. Мы видим сейчас, что идеи, которые мы только обсуждали осенью 2025 года в Рио-де-Жанейро, сегодня уже находят свое конкретное воплощение как в национальных ассоциациях, так что важнее в нашем глубоком взаимодействии. От лица Ассоциации юристов России хочу поблагодарить Ассоциацию юристов Индии за гостеприимство и организацию мероприятия на столь высоком уровне. Желаю всем нам, участникам форума, продуктивных и интересных обсуждений. Спасибо.
Thank you so much. Now may I request the President of Law Society of South Africa, Mr. Motlong, to kindly deliver his speech.
Program Director, the leadership of BRICS Legal Forum, the host, the Bar Association of India, heads of delegation, members of the judiciary, leaders of the legal profession, distinguished delegates, ladies and gentlemen. Namaste, Tumelang, Sanbonani, good morning. I have the honor of leading the South African delegation and addressing this forum in the capacity as President of the Law Society of South Africa. I bring warm greetings from South Africa, particularly from the South African legal profession, and express our sincere appreciation to the Bar Association of India for the generosity and hospitality extended to us here in New Delhi. India's constitutional tradition, the scale and diversity of its society, and its distinguished contribution to global legal thought makes it a fitting place for us to consider the next phase of BRICS plus legal profession. BRICS Club of Nations, which over time has exponentially grown from a mere 5 countries to where we are now, is a political architecture, and all other things have to fit in this political architecture. The BRICS arrangement has been, to a large extent, a response to what may be perceived as difficulties of the global government system, starting with the domination of the world by the G7 countries and the United States leading the G7 countries with all the arrogance that they can muster. The domination of the G7 countries in the IMF and the World Bank system. For example, they have decided amongst themselves that only an American can be the president of the World Bank, and only a European can be the managing director of the IMF. The G7 also dominate the United Nations. You may not agree with me, but they also dominate the thinking in the International Criminal Court. For approximately a decade, this forum has created a valuable platform for dialogue. It has built professional relationships, deepened understanding between different legal systems, and identified important areas of common concern. That foundation must be acknowledged. But the question before us today is not simply what we have discussed during the past 10 years. The more demanding question is this: what will be the next 10 years? Our progress can no longer be measured only by the number of meetings we convene, the declarations we adopt, or the goodwill we express. It must be measured by the institutions we establish, the practitioners we train, the enterprises we assist, the disputes we prevent, and the legal barriers we remove. The time has come to move from dialogue to delivery. South Africa approaches this task with a particular historical constitutional experience. We know now that the law can be used to entrench exclusive or exclusion and inequality. We have also learned that the law can be reconstructed to protect human dignity, restrain the abuse of power, and widen social and economic participation. That history makes us impatient with a rule of law that exists only in legislation, court judgments, or conference declarations. The rule of law must be experienced in the daily lives of people. Its true test is whether an ordinary person can reach a court, whether a small enterprise can enforce a contract, whether public decisions are transparent and reviewable, whether lawyers can perform their duties independently, and whether investors, workers, and communities can rely on rules that are clear, fair, and consistently applied. For South Africa, the rule of law is not merely a constitutional ideal. It is economic infrastructure. Just as economies require reliable energy, roads, ports, and digital connectivity, they require enforceable contracts, independent courts, credible dispute resolution institutions, and confidence that public power will be exercised lawfully. When these institutions are strong, the law becomes a shock absorber. It enables societies to anticipate risks, cushion vulnerable communities and businesses, channel disputes into credible processes, and restore confidence after a crisis. When these institutions are weak, uncertainties increases, transactions are delayed, investment retreats, and the greatest burden falls upon those least to carry it. Legal delay is not neutral. It challenges or changes with survive. BRICS Plus that does not require identical legal system. Our different constitutional arrangements, legal traditions, and economic conditions must be respected. South Africa does not come to this forum with a national model that we expect others to copy and paste. We come with experience to share, lessons to offer, and an equal willingness to learn. We should pursue practical interoperability rather than artificial uniformity. We must build legal bridges that enable our different systems to work together. South Africa accordingly places two practical proposals before this forum. The first is about responsibility. We propose the development of BRICS Legal Resilience Compact, which is supported by a focused legal implementation council. The compact should contain practical commitment relating to faster cross-border enforcement, model contractual provisions for periods of crisis, restructuring and business rescue mechanisms for smaller enterprises, trustworthy digital signatures and evidence, and integrity safeguards for emergency procurement and reconstruction. The Legal Implementation Council should translate those commitments into specific projects. Every project must answer 4 questions. 1, who is responsible? 2, what must be delivered? 3, by when must it be delivered? And lastly, how will progress be measured? At the next forum, our opening session should begin with an honest reflection and report on what has been achieved and what remains outstanding and why it remains outstanding. We cannot perpetually have sessions such as this being reduced to talk shops. We should be in a position to measure how far we've gone and progress achieved. The second proposal is about capacity. We support the establishment of a networked BRICS Plus arbitration and mediation academy. We acknowledge the valuable initiatives already undertaken to advance this work by our Russian colleagues. Our objectives should not be to duplicate that work, but to connect and strengthen it. The academy should not become another expensive headquarters of administrative structure. It should be a shared network drawing upon existing universities, law societies, bar associations, arbitration centers, and experienced practitioners through BRICS Plus. It should provide a common core curriculum, multilingual legal resources, practitioner and faculty exchanges, practical case simulations, and specialist training in arbitration, mediation, and dispute prevention. Its program must deliberately create opportunities for young legal practitioners, in particular women and lawyers from historically underrepresented communities. South Africa is prepared, in partnership with other African legal institutions, to run with this project. Africa must participate in designing the BRICS Plus legal architect and not merely receive the final product. These proposals, ladies and gentlemen, will require resources. We should therefore be intentional and be unapologetic in inviting the new development bank, which is the product of BRICS, and other relevant development finance institutions to recognize that legal infrastructure is in itself is a developmental infrastructure. A project without identified institution or a budget and as well as a timetable is not yet a project. It remains an aspiration. For this reason, ladies and gentlemen, I propose that this forum should adopt a disciplined approach. No more than 10 priority projects at any given time, and no project should be approved without an accountable leader, a funding pathway, and measurable milestones. The South African delegation supports a New Delhi declaration that is principled, forward-looking, and capable of implementation. But we must remember that the true value of any declaration begins on the day after it is signed. Our economic ambitions must also remain anchored in judicial independence, the independence of the legal profession, accountable government, and respect for human dignity. Economic resilience built without justice will be temporary. Growth that does not widen participation and will ultimately prove unsustainable. Colleagues, 10 years of discussions have given us a foundation. The next decade must be judged by what we build upon it. Let New Delhi mark a change to tempo, from declarations to institutions, from general commitments to measurable work, from annual conversations to sustained cooperations, from aspirations to accountable actions. The Law Society of South Africa is ready to do its part. We are prepared to nominate our focal representative, contribute expertise to the proposed academy, support and develop our practical legal instruments, and help build stronger connections between BRICS Plus and African legal institutions. When we meet again, let us be able to identify the practitioners who have been trained, the enterprises who were assisted, the disputes prevented, and the legal barriers removed. Let BRICS Plus be judged not by the eloquence of its declarations, but by the resilience of its institutions. Let fairness of its market and the confidence that its people place in the administration of justice prevail. Let the rule of law, or the rule of law, is not a brake on economic recovery. It is the mechanisms that allows recovery to move at speed without losing legitimacy. As our founding president, the late Nelson Rolihlahla Mandela reminded us. I quote, "We have not taken the final step of our journey, but the first step on a longer and even more difficult road," unquote. May New Delhi represent that first step, not merely towards another decade of conversation, but towards a decade of disciplined, practical, and measurable action. South Africa is ready to work. Ke a leboha. Ngiyabonga. Thank you. Dayavan.
Thank you so much. May I now request Mr. Adil Fakir, Head of International Cooperation's Emirates Association of Lawyers and Legal Professionals, to kindly deliver his speech.
Normally we have to say good morning, but because some of our friends, they took long time. So now we are saying good afternoon. In Arabic we are saying Assalamu alaikum rahmatullahi wa barakatuh. In Hindi, Namaste. So I am pleased to extend my sincere to, first of all, Brother Prashant Kumar for organizing and hospitality and everything for this 11th legal forum belong to BRICS. And thanks for all distinguished audience participation, BAI members, everyone in this, we can say, ballroom. Thank you for coming, and I'm glad to speak before you here, behalf of Emirate Association for Lawyers and Legal. Actually, in addition, I am great to conversary to you of greeting behalf of Emirates of Association for Lawyers and Legals. Congratulate on Independence Day for India. It was actually last week, 15th of August. And as everybody say, Jai Hind. The UAE may be not possess an ancestral civilization like many other nations, but we have economic strength, a pioneering spirit, and wise leadership that knows exactly what to do, what to say, where and when. So from this point, I would like to start highlighting of United Arab Emirates when they joined BRICS Plus 3 years back on 2024. It was our first joining to the BRICS legal forum. Since that time, we committed to playing an active and influential role of law by participating in the group meeting initiatives and fostering cooperation with our delegates. Economic trade, investment innovation, energy sustainability, AI, all these words, or as a main subject, it should be used in BRICS and BRICS Plus. today, if we talk about ages, who will be attending any kind of BRICS meetings, forums, conferences, them ages is different, let we say 25, 30 plus. So we want to have this idea of BRICS training, studying from the childhood, from who have grade, let we say at least grade 6 or 5. So he should to know what's the meaning of BRICS. As we mentioned it before, and I repeated yesterday, BRICS, it's not just a committee or just normal talk. This is reality what we are living. So from this point, I will not extend long time of my speech. So thanks everybody for coming. I'm glad to thanks all the delegations, and we call it, they are ambassador of the BRICS Legal Forum. Thank you.
Thank you so much. Now may I call upon Mr. Tulu, the President of the Pan-African Lawyers Union, and he's also a justice at the Commercial Court of Justice, Africa, to kindly deliver his speech.
Good morning, good afternoon. My good friend, brother, President Prashant Kumar, the President of the Bar Association of India, Excellencies, guests of honor, the Chief Justice who has left, and also the Honorable Attorney General of the Republic of India, distinguished bar presidents, heads of delegation, esteemed judges, arbitrators, members of the legal profession, ladies and gentlemen, Namaste. Sabhi ko namaskar. Previously, sometime before, I've been in southern part of India, and for the reason that myself and President Prashant know, and quite a number of people I have met thought that I'm Tamil Nadu. So they told me that, and I took that. So since then, I have been working on my Hindi. It's a profound honor to speak on behalf of the African Lawyers Union, PALU, in this important timing on the rule of law framework and institutional capacity building for the economic resilience and innovation and sustainability. On behalf of the Pan-African Lawyers Union, I wish to express our appreciation to the organizers for placing rule of law and legal capacity at the center of our discussion. The choice is significant, as a common practice is to speak about diversification, industrialization, access to finance, infrastructure. We're all behind this stand something less visible and yet equally fundamental: the capacity of our legal systems to make economic commitments credible, enforceable, and sustainable. Road, railway, port, digital platform may connect markets physically, but contracts, investment law, commercial courts, arbitration mechanisms, intellectual property systems, competition rules, and so on, and what makes those connections economically meaningful. In other words, economic resilience requires legal resilience. And that's why this conversation is particularly timely. From the 9th Annual BRICS Forum in Moscow, Russia, which Ethiopia has joined for the first time, the Ethiopian Federal Bar Association, to the 10th conference in Rio de Janeiro, Brazil, We now gather in the ancient historical city of New Delhi as the immediate past president of the Ethiopian Federal Advocates Association, bringing our newly established association into the BRICS forum during its infancy was not an easy decision for me and my council. Amidst many pressing priorities. However, I'm so glad we made it that decision. We are already reaping tremendous benefits while contributing deeply to the group. For Africa, this is particularly important. Our continent has 55 states, multiple regional economic communities, diverse legal traditions, while simultaneously pursuing the continental economic project throughout the African continental free trade area. The common market for Southern and Eastern Africa, COMESA, the FCFTA, is not simply a trade agreement. It is a legal project continental integration would want. Its success depends upon the ability of African states to translate continental commitments into coherent national laws, regulations, and institutions. The African Union identifies the AfCFTA as a flagship initiative intended to deepen integration, strengthen the African position in the global trade, and create a single market for goods and services. Therefore, one of the central questions before us should be, do our legal institutions have the capacity to support the economic ambition that the political leaders have already articulated? Too often, the answer is not yet. Africa has Agenda 2063. We have common market of the Eastern and Southern African countries, COMESA. We have the FCFTA. We have others like ECOWAS, EAC, and so on. The challenge is increasingly the gap between political commitment and legal implementation. A treaty may be signed, but implementing legislation may not follow. A regional commitment may exist, but domestic institutions may not have a capacity to apply it. An investment may be approved, but investor may still face uncertainty concerning permits, tariff barriers, movement of persons, monetary issues, taxation, land right, customs, repatriation, dispute resolution, and so on. Contract may be valid, but it takes years to enforce. Its economic value is diminished. A dispute resolution mechanism may exist on paper, but without competent judges, arbitrators, councils, enforcement institutions, the mechanism cannot provide the certainty that the commerce requires. This is what, when I speak about building legal capacity for economic resilience, it's not simply about writing more laws. It's about building system that can make the law work. What does the legal capacity mean in developing countries' context? For a developing countries like Africa, legal capacity must be understood much more broadly than the number of lawyers or statutes that exist. It encompasses at least 5 dimensions, including legislative capacity, institutional capacity, judicial and dispute resolution capacity, professional capacity, and regional and international cooperation, which is the most important of those. No developing country can build all of this capacity alone. We need this. That's why we need the South-South cooperation. We need peer learning. We need exchanges between courts, arbitration institutions, universities, bar associations, and regulatory bodies. As we need to create a strong professional network connecting Africa with BRICS, BRICS and the other emerging economies, Africa has particular challenges. The African challenge is complicated by fragmentation. Our economies remain exposed to commodity price fluctuations and external shocks. The African Union itself recognized the dependence on commodities and limited value addition that can increase Africa's vulnerability to the external economic shocks. But legal fragmentations has an economic cost. An African entrepreneur seeking to expand across the 5 countries subregions may encounter 5 regulatory systems, different licensing requirements, different tax regimes, different company law, and so on. A foreign investor who may confront uncertainty, not because of the investment is inherently risky, but because the legal environment is difficult to navigate. Therefore, legal harmonization and regulatory cooperation should not be treated as an abstract legal exercise. The other major challenge is corruption. This day-to-day reality is that we need to admit that it clearly deters foreign direct investment by the increasing costs and uncertainty, which distorts investor confidence. They are instruments of the economic development. This is why the work of the African Union, the regional economic communities, the national governments, and professional bodies are very important. And it's also why the partnership between Africa and BRICS Plus countries should include legal cooperation as a central pillar of economic cooperation. What can Africa offer to this conversation? Africa should not come to this discussion merely as a recipient of legal knowledge. We also have experience to share. We have developed an innovative approach to regional integration. We have created continental legal institutions. We have experimented with harmonization across the diverse legal traditions. We have developed arbitration centers and alternative dispute resolution mechanisms. We have experience in creating legal frameworks for development and conditions of limited national resources. And perhaps, most importantly, Africa has learned that legal systems must adapt to development realities rather than simply import legal models. The lesson is clear. Integration is ultimately implemented through the law. What are the principal challenges before us? As an African, from the African perspective, I would identify at least the following. A national capacity remains uneven, firstly. Second, there is a shortage of specialized expertise in increasingly complex areas of international law and regional integration, including commerce. Legal fragmentation increases transactional costs and can discourage cross-border investment. Enforcement remains as important as legislation. Digital transformation is advancing faster than many legal systems can regulate it. And perhaps significant implementation gap between the international commitments and domestic legal and national capacity. These challenges are not insurmountable, but they require a different approach. From legal reform to legal resilience, I would therefore propose the following practical areas of cooperation. First, build BRICS Plus Africa Legal Capacity Network. We should establish a structured cooperation among bar associations, law societies, continental legal organs like PALU, judicial institutions, arbitration centers, and universities. This should not be limited to conferences. Second, create a specialized training in emerging economic sector. Our legal professionals should be trained in infrastructure finance, energy, transition, critical minerals, digital trade, artificial intelligence, fintech, and so on. Third, strengthen commercial justice and arbitration. In my 3-year term presidential plan as the president of the Pan-African Lawyers Union, I have outlined a clear vision for PALU, while upholding our proud legacy in human rights, we are adding another priority, which is a primary focus toward the trade, investment, and continental integration. To achieve this, we must actively strengthen our commercial legal structure by investing in a specialized business benches, judicial training programs, alternative dispute resolutions, mediation and arbitration, and a streamlined enforcement framework. Economic resilience requires a credible answer to a simple question. If commercial relationship breaks away, how quickly can the legal system resolve them? This is the question. Fourth, support the legal harmonization and regulatory interoperability. The objective should not necessarily be identical. Laws everywhere. Rather, we seek compatibility, predictability, and mutual recognition wherever is appropriate. Fifth, make a legal capacity as part of every major economic partnership. When we negotiate on an infrastructure project, trade agreement, investment partnership, or technology transfer arrangement, the legal capacity should not be afterthought. Excellencies, distinguished colleagues, the multipolar order will not be resilient merely because economic power is distributed among more countries. It will be resilient when the institutions supporting that economic order are capable, predictable, inclusive, and trusted. Competent legal profession is economic infrastructure. A transparent investment regime is economic infrastructure. As institutions capable of enforcing rights and obligations are among the foundations of economic resilience. As a president of the Pan-African Lawyers Union, I believe Africa must approach the emerging multipolar order not merely by asking what opportunities the new global order offers for Africa, but also by questioning, one, what is the legal capacity what legal capacity must Africa build to take advantage of those opportunities to a fair and sustainable terms? And equally, we should ask our partners, how can BRICS plus cooperation help us build the capacity together? In terms of training, institution building, exchange of judicial professional expertise, harmonization, digital transformation, and so on. Therefore, let us move from political solidarity to institutional solidarity. Let us move from economic cooperation to legal cooperation. And let us recognize in a multipolar order, countries that possess strong and adaptable and trusted legal institutions will be better positioned, not only for withstand economic shocks, but to shape the emerging global economy. Africa does not seek merely to participate in new economic architecture. Africa seeks to help shape it. And the Pan-African Lawyers Union stands ready to contribute to that endeavor on behalf of the 54 national bar associations in the African continent. Lastly, but not least, in a few days, PALU, the premier continental legal organ, will hold its 16th flagship General Assembly and Conference in Egypt, Cairo, expecting to be attended by hundreds of lawyers from the entire African continent and the international partners and the diaspora. I now remind you to join us in the beautiful and historical city of Cairo, Egypt, which is also a member of BRICS. Before I wind up, I would like to congratulate my good friend, brother, President Prashant Kumar, and his entire council and the government of India for their wonderful reception and excellent organization of this year's BRICS Forum. You have done very well, President. Once again, congratulations. Dhanyavad. I thank you.
Thank you, President. Now I request Vice President of Bar Association of India, Ms. Rachna Srivastav, Senior Advocate, to kindly give the concluding remarks.
Thank you, Dr. Andadita. President, Mr. Prashant Kumar, heads of delegation, Sri Naganand, Vice President, Loesia, Dr. Pujari, Vice President, Bar Association of India, distinguished guests in the audience, Namaste. It is very nostalgic occasion for me today. Prashant, the President, and I are the proud witness to the birth of BRICS Legal Forum in the capital city of Brazil at Brasilia in the year 2014. When I traveled down the memory lane, I remember how the forum traveled to 5 member countries years after years. And now the forum has expanded its family to BRICS Plus and have 11 member countries. After nearly 10 years, almost 10 years, BRICS Legal Forum has returned to India, and we feel proud and privileged to host the members of the forum and also our other distinguished guests, especially the President representing Palu and guests from Malaysia and Nepal. Over the years, the theme of forum at various conferences have changed, but the soul has remained the same. That is the supremacy of the rule of law. The present conference theme, Rule of Law in Multipolar World, Building Legal Capacity for Economic Resilience, is both contemporary and consequential. We are living through a profound transformation of the international order. The world is becoming increasingly multipolar, not only politically, but strategically, and also economically, technologically, and institutionally. The rise of new economic centers, changing patterns of trade and investment, technological disruption, geopolitical tensions, and global crises have created an environment of unprecedented complexity. In such a world, rule of law acquires an importance that extends far beyond the courtroom. It becomes an essential foundation of economic confidence, institutional stability, and national resilience. The theme brings 3 interconnected ideas: rule of law in multipolar world. As economic and geopolitical power becomes more distributed among certain countries and emerging regional centers, legal system must provide stability amid competing interests, jurisdictions, and regulatory models. The rule of law is not merely a constitutional or judicial ideal, it is critical economic infrastructure. In a multipolar global economy, countries that can offer predictable laws, independent institutions, efficient dispute resolution, and regulatory certainty will be better positioned to attract investment, withstand economic shocks, and participate meaningfully in a global commerce. We traditionally understand the rule of law in terms of constitutionalism, equality before law, judicial independence, protection of fundamental rights, and limitations on government power. All these remain indispensable, but there is another dimension that deserves greater attention. The rule of law is also economic infrastructure. An investor who commits capital to a country asks fundamental legal questions. Are contracts enforceable? Are property rights protected? Are regulatory decisions predictable? Is there an independent judiciary? Can disputes be resolved efficiently? Will insolvency laws permit a fair and timely restructuring? Are intellectual property rights protected? Is there effective protection against arbitrary state action? These are not merely legal questions. They are questions of economic confidence. Where law is predictable, institutions creditable, and remedies effective, economic activities flourishes. Where legal uncertainty prevails, transactions costs increase, investment is discouraged, and economic opportunities are lost. Thus, the strength of a nation's legal institutions is increasingly part of its economic competitiveness. Second is building legal capacity. Economic resilience requires more than good legislation. It requires capable courts, effective regulators, competent lawyers, strong institutions, accessible justice, and predictable enforcement. Businesses invest and innovate when they can rely on contracts, property rights, insolvency mechanism, and dispute resolution systems. Building legal capacity therefore requires investments in the entire justice ecosystem. It requires strong courts, effective regulators, competent lawyers, modern dispute resolution mechanism, technologically equipped institutions, and continuous legal education. Judicial capacity is particularly important. A commercial dispute that remains unresolved for years can destroy the economic value of the underlying transaction. Delayed justice may therefore become, in economic terms, a denial of commercial justice. The development of specialized commercial courts, insolvency mechanism, mediation, arbitration can significantly strengthen economic resilience. Third is economic resilience. Supply chain disruptions, geopolitical tensions, technological change, cyber risk, climate-related challenges, and financial instability have demonstrated that economic needs legal framework capable of responding quickly without sacrificing constitutional values or due process. Economic resilience cannot be measured only by GDP, foreign investment, or market capitalism. It must also be measured by the capacity of ordinary citizens, small businesses, and vulnerable communities to obtain justice. Small and medium enterprises are particularly vulnerable to delayed payments, contracts breaches, regulatory uncertainty, and prolonged litigation. If access to justice is expensive or inaccessible, the economic consequences can be substantial. Therefore, legal aid, arbitration, mediation, simplified procedures, affordable dispute resolutions, and accessible courts are not merely social policy measures. They are also instruments of economic development. A resilient economy requires resilient citizens and resilient institutions. Economic resilience requires legal institutions that are capable of responding to economic change. The great challenge of our time is not simply how to create wealth. It is also how to create stable, sustainable, and inclusive prosperity in an increasing complex world. The answer lies partly in economics, partly in technology, and partly in geopolitics. But at its foundation lies the law. The rule of law creates trust. The trust creates investment. Investment creates opportunity. And institutions capable of sustaining trust create resilience. I will like to conclude with these words, but before I conclude, I would like to inform also that BRICS arbitration network is at advanced stage. Russia has already initiated BRICS Arbitration Academy, and Bar Association of India has also established, as you can see, BRICS Arbitration Center and Bar Association of India Academy of Professional Excellence. I wish all my guests a very pleasant stay and enjoy your stay and visit all the other places also. Thank you very much.
Thank you so much. With that, we come to the close of the first session. However, without taking any break, we would continue with the next session. Before that, I would request all the head of the delegates to kindly come forward. We will take an official photograph. Thank you so much.